The Aaron Spencer case, we are going to go over the motion to dismiss on Fifth Amendment grounds. Now, this should be interesting because when we think of the Fifth, it's usually people pleading the Fifth against self-incrimination. But dismissing a case on Fifth Amendment grounds is something I think we might all find interesting. So I am the loud little ducky. Let's jump into this motion. We have the defense's motion here, and then we even have the state's response. Let's get cracking. This was filed August 26, 2025 in the Circuit Court of Lonoke County, Arkansas, 1st Division, the State of Arkansas versus Aaron Spencer. This is a motion to dismiss felony information on Fifth Amendment grounds. And it says, comes now the defendant, Aaron Spencer, by and through his attorneys at Lassiter and Casanelli, and for his motion to dismiss this criminal case under the Fifth Amendment to the United States Constitution states. 1. Introduction. 1. The court should dismiss the felony information because it violates the grand jury requirement of the Fifth Amendment of the United States Constitution, and stare decisis is not a license for the state to pursue such an unconstitutional course of conduct. 2. Following the Supreme Court's incorporation of the Sixth Amendment jury unanimity requirement in Ramos versus Louisiana 2020, nearly every core criminal procedural protection in the Bill of Rights has been incorporated to the states through the Due Process Clause of the 14th Amendment. The court's incorporation doctrine under the 14th Amendment ensures that the minimum content of due process is not subject to erosion by the state legislators. 3. The last unincorporated criminal procedural right is the Fifth Amendment's grand jury clause. Whether to require states to comply strictly with the grand jury clause was last considered in Jurado versus California, which was 1884. That precedent, if read today in light of recent decisions and historical precedent, cannot justify a process that strips criminal defendants of a foundational procedural protection. Accordingly, Spencer respectfully requests dismissal of the felony information in this case. So Aaron Spencer's defense lawyers are arguing that because they did not charge him through a grand jury, this case should be dismissed. So they did not go to a grand jury and then the grand jury indict him to go to trial. They went through a preliminary hearing, it sounds like, instead of the grand jury route. And then that judge who did the preliminary hearing, based on what happened there, decided, there was probable cause and all these different things to move forward on charging Aaron Spencer. Now, we can question, why did Lonoke County DA's office or prosecutors not go the grand jury route for a murder? Usually they do. Is it because they knew that the grand jury would have true bill, which means no indictment, that the grand jury would not indict because of the facts and scenario in this case? Is it that it was just easier? Or in this county where they like to do things secretly and people are all connected, is there a corruption to bring charges this way instead of the grand jury because it's easier for the DA's office and prosecutors to do what they want in a case if they have the right judge to just be like, yeah, whatever you say, if you want to charge somebody, you can charge somebody and we'll make sure that this happens. Most states, many states do have it to where you can either go through preliminary hearing or you can go the grand jury route. But what is your opinion? Do you think that in your state or throughout all states across the US, that the only way they should be able to charge people is if they get an indictment through a grand jury, which is a group of like 12 people deciding whether first they think this person should even be charged? And it is just a one-way thing where the defense, or not the defense, the prosecution gets to go up there and tell the things the way that they want to tell them without the defense there. So it's basically just a one-sided argument with nobody saying that what the prosecution is saying or alleging is wrong. And if you can't convict on somebody's one-sided story, or you think that if what they say is true on a one-sided story, if you can't even get people to agree there, you shouldn't be able to go any further. So they haven't been able to get 12 people to agree on anything in this case because they never tried. So do you think that every felony thing, or at least every murder or something, it should always be the grand jury route or not? Should they be able to use preliminary hearings to determine this, or does that allow for more corruption? 2, argument. A, requiring a grand jury felony charges is deeply rooted in history and tradition because it protects the fundamental principles of liberty and justice. 4, the grand jury clause of the Fifth Amendment the Constitution provides no person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury, U.S. Constitution Amendment 5. So this is technically a capital case. Well, it's moved to second degree, so no, it's not a capital case anymore, I don't think. But a first degree, definitely. So, anyways, number 5. Like the U.S. Constitution, the Arkansas Constitution contains a grand jury requirement, and so did 1868 version of the same document, Arkansas Constitution of 1874, as well as 1868. The purpose of the grand jury requirement is to limit a defendant's jeopardy to offenses charged by a person of his fellow citizens acting independently of either prosecuting attorney or judge. United States versus McCourty, a Second Circuit 2009 case, also citing Sterone versus the United States from 1960. The history of the grand jury dates back more than 1,000 years, from the Constitution of Clarendon and the Assize of Clarendon to the 14th century Edwardian advance in criminal procedure design, Roger A. Fairfax Jr., interrogating the non-incorporation of the grand jury clause. That's from 2022. In the 17th century, the cases of Stephen College and the Earl of Shaftesbury saw the grand jury emerge as a valued protection of individual liberty against encroachment by the crown through politically motivated criminal prosecution. So, is this politically motivated? This is a grand jury is kind of like a checks and balance for the courts. So the courts can't necessarily do things. But as we've seen in other cases, just because a grand jury won't indict doesn't mean that they won't try to still go after you. All right, let's continue on with this. The Supreme Court acknowledged the venerable history of the grand jury requirement, including its presence in Clause 39 of the Magna Carta, and debates on whether it should be interpreted to include not only felonies, but also misdemeanors and petty offenses. In Jurado versus California, that 1884 case. However, the court ultimately decided not to incorporate the grand jury clause against the states, holding the states' legislators were free to newly devise any legal proceeding enforced by public authority. so long as they preserve the principle of liberty and justice. So, did Lonoke County, Arkansas, did they preserve the principles of liberty and justice in this case? Number 9, although Hurtado established that a grand jury requirement was not incorporated against the states, the decision did not excuse states from ensuring that their criminal procedures offered at least some form of due process, and it did not require Arkansas or other states to strike the grand jury requirement from their constitutions. Therefore, in Arkansas and similar states, the grand jury requirement remained. However, in 1936, Arkansas amended its constitution to provide that all offenses heretofore required to be prosecuted by indictment may be prosecuted either by indictment by a grand jury or information filed by the prosecuting attorney. Arkansas Constitution Amendment 21:1, emphasis added. The following year, based solely on the court's decision in Hurtado, the Arkansas Supreme Court found that Amendment 21 was constitutional within the meaning of the 5th and 14th Amendment to the U.S. Constitution, ushering in an era of felony charges being filed by a lone prosecuting attorney, Pinton v. State, an Arkansas case from 1937. The state's practice of allowing individual prosecuting attorneys to charge individuals with serious criminal offenses directly controverts the 5th Amendment to the U.S. Constitution. It also creates a risk of executive overreach, which has no roots in history or tradition of this country or the state of Arkansas. To protect the Fifth Amendment rights of Arkansas, the court should dismiss the felony information in this case. B. Although Hurtado did not incorporate the grand jury clause, the rationale of Hurtado has been superseded by subsequent incorporation decisions. The right to a grand jury indictment is solely unincorporated, outlier among the due process protections contained in the Bill of Rights because of the court's decision in Hurtado Supra, which predated the era of selective incorporation. See Fairfax Supra. Says, although Hurtado treated incorporation as a matter of procedural due process, the court now applies a substantive due process analysis for incorporating the Bill of Rights. Although Hurtado is critically important to the 28 states, including Arkansas, that allow a defendant to be prosecuted for a felony without a grand jury indictment, Hurtado should be called into question in light of the court's decision in Ramos. The court's rationale in Ramos reflected the court's rationale in Timms v. Indiana, in which the court explained that a prosecution enumerated in the Bill of Rights is incorporated against the states if it is fundamentally to our scheme of order, liberty, or deeply rooted in this nation's history and tradition. And that's cited from 2019. Internal quotations are admitted accordance to Ramos. A close reading of Hurtado shows the court did not deny the fundamental character of the grand jury right. Instead, the court acknowledged the grand jury's deep roots in both United States history and tradition, and the English history and the tradition that preceded the foundation of this country. The court recognized that the grand jury requirement was safeguard to the fundamental principles of liberty and justice. What it rejected was not the idea that individuals had a fundamental right to be free from deprivations of liberty exceeding the limitations established in the Bill of Rights, but the idea that due process clause of the 14th Amendment required identical procedure mechanisms in state and federal prosecutions to preserve the fundamental principles of liberty and justice. In doing so, the court avoided conflict with his previous decision in Murray's Leasy versus Hoboken Land and Improvement Co. from 1855. In Murray's Leasy, the court had held that due process requires adherence to traditional common law procedures, demonstrating consistency with fundamental principles rooted in history and tradition. Had the Hurtado court followed this analysis, it would likely have concluded that replacing a grand jury indictment with a unilateral prosecutorial information was incompatible with due process. However, the 14th Amendment had only recently been ratified, and California, like Western states, was struggling with the practical requirements of conveying grand juries in sparsely populated areas. Robert W. Fay in Corporation Fundamental Rights and the Grand Jury Jurado v. California Reconsidered from 2022. In that context, prior to the court's incorporation decisions of the 20th and 21st centuries, the court concluded that California's practice of proceeding on information filed by an individual prosecutor was not sufficiently unfair or oppressive to violate the 14th Amendment. The differential procedural due process standard sets Jurado apart not from Murray's Lisi, but also from the court's more recent incorporation decisions, in which it has reviewed criminal procedures as a matter of substantive due process. Spencer's motion does not require this court to overrule Jurado, only to read it narrowly in the context of Murray's Lisi's. A narrow reading of Jurado establishes that although a felony information may satisfy the minimal requirements of procedural due process, a substantive due process analysis requires dismissal of felony information in this case. Recent incorporation decisions establish that Fifth Amendment and Sixth Amendment criminal procedural rights apply identically to states as to federal prosecutions. As previously established, the Jurado court did not find a state's process for filing felony charges to be outside the scope of the 14th Amendment's due process clause. Instead, Jurado court decided that due process meant any process that was legislatively intended to safeguard the fundamental principles of liberty and justice. In the many years since Jurado, the court has overruled most of its precedent from the 19th century, expressly holding that the 14th Amendment's due process clause does in fact require that courts apply an identical definition of due process to state prosecutions as to federal prosecutions. This trend reflects that Justice Black considered to be the original purpose of the 14th Amendment to extend to all people of the nation the complete protection of the Bill of Rights. To hold this, court can determine what, if any, provisions of the Bill of Rights will be enforced, and if so, to what degree, is to frustrate the great design of a written constitution, 1947. In 2010, the Supreme Court of the United States published the following list of its decisions, fully incorporating provisions of the Bill of Rights against the states. And it lists all those there. And more listed here. In 2020, the court added the Sixth Amendment's implied requirement of jury unanimity to its list of provisions from the Bill of Rights that apply identically to the states, Ramos v. Louisiana from 2020. In Ramos, the court acknowledged that the enumerated jury unanimity requirement had never previously been applied to the states. Even in Apodaca versus Oregon 1972 case, directly on point. Nevertheless, Ramos Court expressly overruled Apodaca and found that Sixth Amendment required jury unanimity both in federal prosecutions and in state prosecutions. It did so despite the thousands of cases in which state courts had relied on Apodaca and despite the potential crushing burden on the courts and criminal justice systems that fully incorporating the jury unanimity requirement might impose on states. The Ramos Court explained that once a right has been incorporated against the states by the 14th Amendment, that the right cannot be interpreted to mean two different things, depending on whether it is being invoked against the federal or state government. Thus, Ramos should be read as implicitly superseding Jurado, by prohibiting states from obtaining felony criminal convictions by procedures that, although they may be arguably consistent with the principles of liberty and justice, are not identical to the federal government's criminal procedures. 4 years after Ramos, the court explained the crucial importance of the jury trial rights, both enumerated and unenumerated, of the Fifth and Sixth Amendments. Thus, the Sixth Amendment promised that in all criminal prosecutions, the accused has the right to a speedy and public trial by an impartial jury. Inherent in the guarantee is an assurance that any guilty verdict will issue only from a unanimous jury. Ramos v. Louisiana. The Fifth Amendment further promises that the government may not deprive individuals of their liberty without due process of law. It safeguards for criminal defendants well-established common law protections, including the ancient rule that the government must prove to a jury every one of its charges beyond a reasonable doubt. Together, these amendments place a jury at the heart of our criminal justice system and ensure a judge's power to punish is derived woefully from and remains always controlled by the jury and its verdict. And then there's some citing of a 2024, a 2024 case and a 2004 case. Although the court's justices have offered somewhat different explanations for the court's recent incorporation decisions, their message is clear. States must comply with the jury requirements contemplated by the framers, or their action will be found unconstitutional upon review by Supreme Court of the United States. McDonald. So I say farmer and then it says McDonald. So, old McDonald had a farm. Anyways, this court has abandoned the notion that the guarantees in the Bill of Rights apply differently when incorporated against the states than they do when applied to the federal government. Justice Alito, writing for the plurality in McDonald, argued the well-settled principle that fundamental rights guaranteed in the Bill of Rights are incorporated against the states by the 14th Amendment Due Process Clause. Justice Thomas concurred with Alito's plurality, but he opined that complete incorporation was necessitated by the plain language of the 14th Amendment's Privileges or Immunities Clause, rather than the Due Process Clause. Thomas J. concurring in part and concurring in judgment. Thomas repeated this argument in his Ramos concurrence 10 years later. Regardless of which clause the court prefers, both analyses point toward finding that the 14th Amendment requires Arkansas to strictly comply with the 5th Amendment grand jury clause. Since the Jurado court determined that the 14th Amendment Due Process Clause governs the review of how a state files serious criminal charges against individuals like the defendant in this case, and the Ramos court determined that the Due Process Clause requires uniformity in the protection of constitutional rights between the state and federal criminal justice systems. These two cases taken together suggest that the state's failure to comply with the 5th Amendment grand jury clause incorporated under the Due Process Clause requires the dismissal of a felony information in this case. So he's stating that because of this serious felony, they should have done this under a grand jury and not the way that they've done it. And because they didn't do it by way of grand jury, they should dismiss it. Likewise, since the plain language of the 14th Amendment's Privileges or Immunities Clause provides that no state shall make or enforce any law which shall abridge the privileges of immunities of citizens of the United States. The jury requirements of the 5th and 6th Amendments, both enumerated and unenumerated, protect individuals from deprivations of liberty imposed by an individual representative of the executive branch rather than a jury. The language of the U.S. Constitution suggests that a state may not, as here, file felony charges leading to an arrest of an individual like this defendant with any process involving a greater risk of arbitrariness than putting the question to a grand jury. So they should have put the question to a grand jury and not just left it up to one prosecuting attorney and like a judge and stuff. Ramos and the other recent incorporation decisions demonstrate that it is just a matter of time before the Supreme Court of the United States incorporates the grand jury requirement and invalidates virtually every felony prosecution pursued in the state of Arkansas. Accordingly, the defendant respectfully requests that the felony information in this case be dismissed. Now we're getting to C. Amendment 21 to the Arkansas Constitution violates the Fifth Amendment to the United States Constitution. Jury trial rights exist to prevent oppression by the government and provide a defense against arbitrary law enforcement. Duncan v. Louisiana from 1968. Those who wrote our Constitution knew from history and experience that it was necessary to protect against unfounded criminal charges brought to eliminate enemies, and against judges too responsive to the voice of higher authority. Providing an accused with the right to be tried by a jury of his peers gave him an inestimable safeguard against corrupt or overzealous prosecutor and against the complaint biased or eccentric judge. So they're saying that the grand jury, like I had said earlier, is basically the check and balance to a corrupt or overzealous prosecutor, trying to get rid of enemies of theirs, people they don't like, people that are causing problems, maybe uncovering such things and truths, or judges that are biased or eccentric. And we've already seen, even with the gag order that's the Arkansas Supreme Court came down and thought this judge needed to go away anyways because of how she handled herself. And so Aaron Spencer, they're saying, should have had a grand jury do this and see if they could have gotten it that way, because it can't be trusted when you have prosecutors and judges not doing things ethically. Both under English common law and under the United States Constitution, the jury exists at the heart of our criminal justice system to ensure a judge's power to punish is derived woefully from and remains always controlled by the jury and its verdict. Courts should act affirmatively to protect jury rights from encroachment because, as constitutional scholar Suja A. Thomas observed when she argued in favor of incorporating the remaining jury-related rights in 2012, prior to the express incorporation of the jury unanimity right by the court in Ramos Supra. The jury shares with the competes with the judiciary for power, but the jury cannot do anything to regain power when power is taken away from it. Suja A. Thomas. Non-incorporation, the Bill of Rights after McDonald v. Chicago, 2012. As previously established, the framers of the existing Arkansas Constitution acted affirmatively to protect the grand jury right enshrined in the Fifth Amendment to the U.S. Constitution when they drafted Article 2, Section 8 of the Arkansas Constitution. However, Amendment 21 purports to take that right away. When Amendment 21 has been challenged under the Fifth Amendment, the Arkansas Supreme Court has relied on Jurado to affirm its constitutionality. The Arkansas Supreme Court will strike an amendment to the Arkansas Constitution when that amendment directly conflicts with the U.S. Constitution. See United States Term Limits versus Hill, 1994, striking Amendment 73 to the Arkansas Constitution because it imposed an additional eligibility requirement on candidates for the Arkansas delegation to the U.S. Congress in violation of the 10th Amendment to the U.S. Constitution. Nevertheless, in 1937, the Arkansas Supreme Court affirmed the constitutionality of Amendment 21 because of Jurado, and subsequent decisions relying on the same case. Let's see. And then they cite a case and says, citing Jurado for the proposition that prosecution by information instead of by indictment is not a violation of the federal constitution. And Spies versus Illinois from 1887, citing Jurado for the proposition that the Due Process Clause did not necessarily require an indictment because an accusation by a preliminary examination was equivalent to an indictment. The Arkansas Supreme Court's subsequent decisions reaffirm Amendment 21 are based solely on the principle of stare decisis, Gardner v. Payne from 2022. This court has held that Amendment 21 to the Arkansas Constitution, which permits indictment by information, is constitutional. The court has held many times that Amendment 21 to the Arkansas Constitution is constitutional, citing some more cases relying on Jurado for the proposition that states are not required to charge by indictment but may charge by information. Ham v. State, declining to overrule prior decisions regarding the constitutionality of filing felony charges in the absence of a grand jury. Moore finding no need to reconsider prior cases, finding Amendment 21 to be constitutional within the meaning of the 5th and 14th Amendments to the U.S. Constitution. It says, given the development of the constitutional law since Jurado, existing Arkansas precedent is demonstrably erroneous. Notwithstanding the principle of stare decisis, the Arkansas Supreme Court will abandon existing precedents when they're demonstratively erroneous. Existing precedents of the Arkansas Supreme Court are demonstrably erroneous when they conflict with the United States Constitution as interpreted by the Supreme Court of the United States. Although the Supreme Court of the United States has found all but one criminal due process right enumerated in the Bill of Rights to be fully incorporated against the states under the Due Process Clause, the court has, in its own words, shed any reluctance to hold the rights guaranteed by the Bill of Rights meet the requirement for protection under the Due Process Clause. Okay. In 2010, the court added to its list of enumerated rights that have been incorporated against the state by holding that the Second Amendment is fully incorporated against the states because the right to bear arms is deeply rooted in the nation's history and tradition. Likewise, in 2020, the court held that the Sixth Amendment jury unanimity requirement is incorporated against the states under the Due Process Clause. Even a right that is not enumerated in the Bill of Rights may be incorporated against the states under the Due Process Clause. In 2024, the Supreme Court of the United States held that the common law right to be sentenced based on a jury's finding of facts beyond a reasonable doubt, rather than based on judges' findings of additional fact based on the preponderance of the evidence, is incorporated against the states because it is a fundamental right. Because the Supreme Court of the United States has abandoned its precedents related to non-incorporation of certain rights, neither Amendment 21 nor the principles stare decisis prevents this court from dismissing this felony information as a violation of the Fifth Amendment grand jury clause. Existing Arkansas precedents is demonstrably erroneous because it leads to a result that is manifestly unjust. In Arkansas, precedent governs until it gives a result that is so patently wrong or manifestly unjust that a break becomes unavoidable. Although Arkansas precedent is to uphold constitutionally or the constitutionality of Amendment 21 based on the 1884 Gerardo case as applied by the Arkansas Supreme Court in the 1937 Penton case. This precedent has led to an absurd result. In Arkansas, a prosecutor, disappointed by grand jury's refusal to indict an individual with capital murder or infamous crime, may turn around and file the serious charge unilaterally, directly controverting the demonstrated will of the people. The executive branch of government is the closest thing to the crown that exists in the modern United States, and a prosecutor is a representative of the crown. It was against the crown overreach that early Americans sought to protect themselves when they revolted and established the United States Constitution and when they ratified the Fifth Amendment. Nevertheless, in Orsini, the Arkansas Supreme Court upheld the constitutionality of allowing a lone prosecutor take a second bite at the charging apple by filing an information violating not only the grand jury clause, but also the Arkansas General Assembly statute requiring good cause and the court's permission to go forward with felony charges after a sitting grand jury has determined no charge should be filed. Section D of the statute expressly requires, unless an indictment is found at the terms of the court, next after the first submission of the charge to the grand jury, the defendant shall be discharged from custody or exonerated from bail unless for cause shown. The court shall otherwise direct. Thus, according to the legislator, the only two permissible exceptions to the statutory requirement of discharge or exoneration are 1, if a grand jury returns an indictment, or 2, if court finds good cause not to discharge/exonerate the accused. In this context, Arkansas precedent regarding Amendment 21 and Fifth Amendment creates a loophole that was not intended by the legislator. The unintended loophole creates a manifestly unjust legal landscape, wherein a person may be charged with a capital crime or other serious felony by an individual member of the executive branch who has already been told by multiple authorities, including 2 constitutions, the Arkansas General Assembly, and a jury with knowledge of the facts of the specific case, that the person should not or should be allowed to go free. Both the manifest injustice of the result and the demonstrably erroneous nature of existing Arkansas Supreme Court decisions, given the trend towards the total incorporation of all due process rights by the Supreme Court of the United States, require a break with existing precedent, and the court should dismiss this felony information accordingly. Conclusion. An individual's Fifth Amendment right to be free from serious criminal charges, except those charges in the or by the indictment of a grand jury, shields not only this defendant, but all of us from exactly the sort of deprivations of liberty without due process that framers sought to prevent. Rather than continuing down a path of affirming prosecutors' purported power, even if it contravenes the express will of a grand jury, to unilaterally charge people with capital crimes and other serious felonies, this court should look to the language and intent of both relevant constitutions with due consideration to the development of constitutional law in this area since 1884, and it should find that the felony information in this case violates the Fifth Amendment's grand jury clause as incorporated by the 14th Amendment. Wherefore, the defendant Aaron Spencer respectfully requests that this court dismiss the felony information in this case for violating the Fifth Amendment grand jury clause. And it is signed by Aaron Spencer's lawyer and served to the prosecution. It was filed June 20th, 2025. So that is their motion to dismiss on like Fifth Amendment grounds. Now we're going to look at what the state's response to this. State's response is much shorter. While I get what they're saying, and we can all have our views on it, and I want to know what your views is. Should all these types of charges go through a grand jury and the grand jury decides, and if the grand jury says no, should they be allowed to go forward? Or should they just be allowed to go another route instead of the grand jury route? Or should grand jury be the only way forward on these things? Because if you can't even convict or get somebody to say, yes, let's prosecute in a grand jury, how, and this is with nobody questioning you, and you just get to tell it your way. If you can't even get an indictment from a grand jury, how are you going to convince 12 people that beyond a reasonable doubt, with now people able to poke holes and blow up your case, how are you going to be able to convince 12 more people or just 12 people in general? I think it's a good test to test your case. And if the grand jury says no, I think it should stop right there until maybe you have more or something else. But if you can't even convince the first 12 without anybody contradicting what you're saying, I just don't know how you think you should be able to go forward to try to convince another 12 or 6 or 8 or whatever. But for this type of case, it's going to be 12. So let me know what y'all think about that. Do I think that the judge is going to be like, okay, yeah, sure, dismiss? No. And obviously this case is going forward, so obviously the judge does not dismiss based on this motion. But we get a good history lesson, at least for Arkansas and some of the United States, in regards to this question and what they should be doing. So, state's response to defendant's motion to dismiss felony information on Fifth Amendment grounds. This was filed October 3rd, 2025, and it says, comes the state of Arkansas by and through prosecuting attorney Chuck Graham, and for its response to the defendant's motion to dismiss felony information on Fifth Amendment grounds hereby states, argument. Spencer's motion to dismiss has framed the state's filing of criminal information in this case as a failure to comply with the Fifth Amendment. This is not so. 28 states currently file criminal charges by information. See footnote 1. The states are Arizona, Arkansas, California, Colorado, Connecticut, Hawaii, Idaho, Illinois, Indiana, Iowa, Kansas, Maryland, Michigan, Missouri, Montana, Nebraska, Nevada, New Mexico, North Dakota, Oklahoma, Oregon, Pennsylvania, South Dakota, Utah, Vermont, Washington, Wisconsin, Wyoming. When indictment is required, state prosecutions, grand jury law, and practice. So those states that I just listed do not have to go the grand jury route. So if you live in any of those states and you think that people should have to go the grand jury route, maybe see what you can do about it. Research it more. Talk to your legislators. If you don't think that you should be able to do this. But it says when indictment is required, state prosecutions, grand jury law, practice, the current controlling state and federal precedent does not require states to use grand juries. Spencer's reliance on Ramos v. Louisiana is misplaced. Ramos concerned the requirement of unanimous verdict in trials by juries under the Sixth Amendment, not the mode of charging under the Fifth Amendment. That decision did not overrule Jurado versus California from 1884, which clearly held that the states do not have to indict by grand jury. While Spencer's motion presents scholarly arguments that under modern incorporation jurisprudence, the grand jury clause should be recognized as fundamental, those arguments remain outside the holdings of controlling precedent. This motion must fail as a matter of current constitutional law. While Spencer alleges that he is not requesting this court to overrule Jurado, That is what would be required in order to grant Spencer's motion. It is well settled that states are not required to charge by indictment, but may charge by information. Gerardo v. California. The Arkansas Supreme Court has addressed the issue many times and has consistently refused to extend the right to grand jury indictments to proceedings in this state. While much of the case law that has reiterated this well-settled matter is prior to Ramos' ruling, the Arkansas Supreme Court has stayed consistent even since Ramos was decided. The Ramos opinion was issued April 20th, 2020. The defendant in Waller v. State, which is also 2020, but it was issued in November, so after Ramos, filed a pro se petition for writ of habeas corpus. The defendant had been convicted of first-degree murder, arson, and first-degree battery. Among other arguments, the defendant alleged in his petition and in his argument on appeal that no grand jury indictments were issued for the charges of arson and battery. At that same time, the Arkansas Supreme Court reiterated, citing Barber, Kelly, and Gerardo v. California, post-Ramos, that the right to grand jury indictment proceedings does not extend to the state of Arkansas. Maybe it should. Wherefore, the state of Arkansas respectfully requests that this honorable court deny the defendant Aaron Spencer's motion to dismiss. And I kind of agree there. Arkansas is one of the states where you do not have to be indicted by a grand jury. And out of all those 28 states that I listed, Arkansas is one of them. And if we don't like it, somebody's going to have to change legislative stuff there and in the rest of the 28 states. But right now, I don't think that's a way for a motion to dismiss. It is respectfully submitted by Chuck Graham, and who is the prosecuting attorney, and Marianne Bird, deputy prosecuting attorney, and then they served it on Aaron Spencer's defense firm. So while I think the defense team is doing their job and throwing, in defending their client and trying a lot of different avenues, I just don't think that in Arkansas this argument would work anywhere. It definitely is not going to work in this case in Lonoke with the people that are in power in the courts over there. But let me know your thoughts, and we will continue covering this case. Hit the like button, subscribe, turn those notification bells on so you never miss a video, and I will see you next time.